Thank you. Good morning. It's good to be here this morning. Thank you so much, Nan. I appreciate the invitation to be here. I am very pleased to be here with the Alliance for Justice. You all have been doing remarkable work, and I'm just glad to be able to add my voice to that and to all the organizations that helped put this together this morning. And for those of you on the West Coast, this early morning. Hey, but you're still in your bunny slippers, right? So, there are pluses and minuses. We're all dressed here. So I also am pleased to be here this morning with Judge Nancy Gertner because she is not only has had a distinguished career both as a lawyer and as a federal judge, but also because she serves as the chair of our advisory committee on Massachusetts judicial nominations, and she has already helped bring three very illustrious candidates forward for nomination to the federal bench. And I just want to thank you for your efforts on that behalf. And I know it'll be a terrific panel that follows here. So I am so glad to be here this morning to talk about something that is so important, and very glad that you're having this conference, to talk about professional diversity on the federal bench. There is an intense fight going on right now about what our federal bench will look like. Will it be a neutral forum that faithfully interprets the law and dispenses fair and impartial justice, or will we see corporate capture of the federal courts, with the courts transformed into just one more rigged game? That's really what's at issue here. And we should put this in some context. We're here in Washington, and here in Washington, power is not balanced. Instead, power is becoming more and more concentrated on one side. Well-financed corporate interests line up to fight for their own privileges and to resist any changes that would limit corporate excesses. I saw one of these examples up close and personal following the 2008 financial crash, where all of the large financial institutions came in and fought vigorously to protect themselves, not to protect the public, but to protect themselves in an ongoing battle and an effort to try to re-regulate the financial institutions. I saw it there, but it has been replicated on and on and on throughout our system, where large corporate interests come in, they make sure that their interests get protected, they get the opportunity to tilt the playing field. Now, in a democracy, when we write our laws, we at least have some opportunity to get back in and have some reasoned debate, to get the public involved in a debate, to get some public awareness, and to fight for something that balances the playing field in the other direction. I think getting the Consumer Financial Protection Bureau is an example of that. The banks resisted it mightily, but in the democratic process, we at least had a shot to be able to get through something that was there for the people. And in that case, we succeeded. That's how we got the consumer agency. But if big businesses lose in the Democratic forum here in Congress, if they lose in the legislative forum, then if they can rig the courts, then they get a second bite at the apple. They get a second chance to have the outcomes that they want. And that's part of the reason it is so important that we maintain courts that are independent, that courts that represent a diversity of views from around this country, in order to be neutral arbiters rather than part of the rigged system where they just have a second bite at capturing the law and the legal system again. So this is one of the reasons that I believe professional diversity matters so much in our court system. Professional diversity is one way to insulate the courts from corporate capture. Now, however, we face a federal bench that has a striking lack of diversity among the lawyers who are serving. The American Constitution Society did a study in 2008 where they looked at the federal bench, they looked at the biographies of those who served on the federal bench, and they concluded that the federal appellate bench was, quote, dominated by judges whose previous professional experience is generally corporate or prosecutorial. They looked at the biographies of 162 judges in the Almanac of the Federal Judiciary. 85% came out of private practice. They said their conclusion was, it is clear from the judges' biographies that a sizable number of them worked for large, well-known firms that tend to represent corporations. President Obama has supported some notable exceptions, but as the report that will be discussed today from the Alliance for Justice shows, the president's nominees have thus far been largely in line with the prior statistics. 71% of the president's judicial nominees have practiced primarily for corporate or business clients, while only 25% are not corporate attorneys. That means that corporate attorneys outnumber all other kinds of attorneys by 3-1 in the president's nominees to the federal bench. Only 8 district court nominees and 2 circuit court nominees have been attorneys in the public interest. That's only 3.6% of President Obama's appointees have a background in public interest organizations. Now, be clear about this. There are some really talented judges who came from the private sector. I've worked for private clients. I understand that a lawyer's views may not be the same as those of his or her clients, but I believe that diversity of experience matters. It matters that someone has represented people other than corporate clients, that they've had real experience with people who can't afford lawyers, that they've had real experience trying to fight for the public interest, that they've had real experience doing something other than representing corporate clients. You know, Justice Byron White praised the professional diversity that Thurgood Marshall brought to the Supreme Court, noting that he brought to the conference table years of experience in an area that was of vital importance to our work, experience that none of us could claim to match. Justice White was right. It matters where you come from. Until recently, the judicial nominations process was largely held hostage to an intransigent Republican minority that looked for any excuse to block President Obama's efforts to nominate federal judges. Now, it's unsurprising in those circumstances that the president and the majority of the Senate gravitated toward nominating corporate lawyers and prosecutors that even the most conservative senators could not object to. But that has changed. The bizarre Republican refusal to confirm any judge to the D.C. Circuit Court of Appeals, anyone, regardless of qualifications or professional experiences, led the Senate to eliminate the filibusters on judicial nominations. And with this change comes an opportunity to build a federal bench that reflects the best and the brightest from every corner of the legal profession, an opportunity to ensure that the next generation of judges will be fair, even-handed, and will have the broad experience to fairly consider all sides of a dispute in the issues that come before them. One of President Obama's early nominees was District Court Judge Edward Chin, who worked for many years as a staff attorney for the ACLU. President Obama stood behind the Chin nomination. He had to renominate him 3 times over 3 years before the Senate finally confirmed him. When he was sworn in Judge Chin said that despite the obstruction that he faced during this time, he never even considered withdrawing from consideration. Why? Judge Chin's words, because the federal bench is not just for people from large corporate law firms or who represent only the wealthy or who never speak out or who play it safe in their careers. Judge Chin is right. We must fight to make his words a reality if we are to ensure that there will be professional diversity on the bench and that our federal courts will be a neutral forum that fairly consider all sides of an issue in every dispute that comes before them. This is the opportunity we have. This is the opportunity we must seize. Thank you. Thank you. Thanks, Dan.